I'm immigration lawyer Mark Northam.
And I'm registered migration agent Monica Gruszka.
And on this episode of The Migration Show, we're going to talk about the dreaded Schedule 3.
So stay tuned for this informative little lesson.
And how you can help your clients navigate the troubled waters of Schedule 3.
Schedule 3.
Welcome to The Migration Show with Mark Northam and Monica Gruszka, the show for Australian migration agents and immigration lawyers, where we talk about the latest Australian immigration law, policy and much more, including your questions. Information discussed on The Migration Show is not intended as legal advice or immigration assistance and is current as of the date of the show's production. However, as migration law frequently changes, you should always refer to updated information. And now, from Sydney, the hosts of The Migration Show, immigration lawyer Mark Northam and registered migration agent Monica Gruszka.
I'm Mark Northam, and welcome to this episode of The Migration Show. Of course, I'm back with registered migration agent Monica Gruszka. Welcome,
Yes.
Monica.
We've got something interesting to talk about.
We do.
Schedule 3.
Or Schedule 3, depending on where you come from.
That's right.
Well,
It's still a 3.
it's a 3 as opposed to a number 1 or a number 2.
That's
is that
exactly,
right?
but that's what we do. We're doing
Well,
number 1 or a 2.
Schedule 3 make you want to
feel
do
like,
a number 1 or
one
number 2. Well, I don't know.
No, it's true.
It's difficult.
It's a bit of a worry.
A bit of a worry. And it affects, of course, applicants who apply for certain visas, mainly onshore partner visas, while they're either not holding any visa or they're only holding a bridging visa.
Yes.
Now, we're not going to explain Schedule 3. You can read the legislation. We want to talk about some of the broad strokes in terms of strategies and tactics that you can use.
Yes, very important.
Now, if you have a client who is affected by Schedule 3, first thing is let them know it. There's nothing worse than, and I hate to say it, but this comes from some folks that might be lawyers that dabble in migration and don't really read the partner visa legislation very well.
That's
right. They don't understand and appreciate the depth and intricacies of Schedule 3.
Intricacies is a really good word.
Well, it
It's
is.
totally delicate.
Complicated.
It's very delicate.
But the long and the short of it is, if you're affected by Schedule 3, either you satisfy the Schedule 3 requirements, all of them, or you get a waiver. It's all the requirements or a waiver. It's not some of the requirements.
It's all 3. 1, 2, 3.
That's right. 3001, 3003, 3004 for
That's
the
right.
82801.
Remember that.
If you fail any one of them, don't worry about trying to pass the rest.
Because you fail all.
That's it. Fail one, fail all.
That's it.
So then it's time for a waiver. Now, in terms of satisfying Schedule 3, as we said, it's critical that you look at all 3 parts for the 820 visa or whatever other visa you're working on. 461 is an interesting visa that also has Schedule 3 requirements.
That's interesting,
There's
isn't
a
it?
big difference because the 461, there is no Schedule 3 waiver available. You have to look in Schedule 3. Excuse me, Schedule 2.
Yes.
For the visa, and it will say applicant must satisfy sections 3001, 3003, 3004, unless the minister believes there are compelling reasons not to. That's the 820 version of that. But with the 461, it is simply you must satisfy boom, boom, and boom, whichever parts of the Schedule 3. There is no unless the minister thinks it's compelling.
That's right, it's a big case, isn't it, if you have to do that?
That's it. And it can blow you right out of the water no matter how genuine the relationship may be that you're doing the visa for. So,
agreed.
Job number 1, find out which parts of Schedule 3 apply. Job number 2, see if your client can satisfy Schedule 3, all of the elements that apply for the visa. If the client cannot, then see if there's a waiver available option for that visa. And you have to look for language in Schedule 2 that says something like, unless the minister believes there are compelling reasons not to apply the Schedule 3 criteria. So that's the first part. The second part, waivers, and that's what we'll talk about for the most part.
That's it.
Over half my caseload is Schedule 3 related work.
That's right. You're very, very busy on Schedule 3.
I've somehow gotten a reputation for that. Better or for worse, as they say. And look, it used to be a very simple matter to get a Schedule 3 waiver because in PAMS, in the policy, there was about 10 different reasons that were essentially ended up being prescribed reasons why that would represent what are called compelling reasons. That's the target you've got to meet with the Schedule 3 waiver for an onshore partner visa. Do the circumstances represent compelling reasons? Well, what does compelling mean?
Well, that's it. So what is the definition for the Department of Home Affairs for compelling?
Or for anybody?
That's exactly right.
Well,
let's go through that together because it's interesting.
The problem is there is no definition.
That's exactly right.
It's like beauty is in the eye of the beholder. And there are some cases you can read about, including the case of Babici, that sort of begin to define or describe what compelling is or isn't, but there's nothing really in black and white. So this is very much a matter of trying to influence the opinion of the decision maker.
That's it.
And help them arrive at your
best
version
conclusion
of exactly
what
what
is
is
right.
compelling.
That's right.
But compelling is one of those words that defies definition. What does it mean? You can look at a picture on the wall. Is that compelling? Well,
yes. Well, that's the best thing about the English language. It's all about interpretation. So if you are ready to go in with Schedule 3 compelling, compassionate circumstances.
but not compassionate.
Compelling. That's
reasons.
Right. That's it.
A common thing that people do is they mix those up. Now, certainly
completely different.
Compassionate things can be considered compelling, but what you want to look at for Schedule 3 waivers is compelling reasons. Now, we're going to be doing a webinar, an online workshop coming up in a week or two, all
Very
about
exciting.
Schedule 3.
And
there'll be a link for that if you wanted to hear me talk at length about Schedule 3 and waivers, and we'll also be providing some samples of Schedule 3 waiver submissions for you to consider.
This is absolutely incredible. If you want to get your hands on some good starting points for a submission, if you are exposed to that part of the migration law, then this is where you want to be because Mark's submissions are incredible.
Oh, that's a paid political announcement right there.
Well, I use them because they are very, very good.
Some
they
people,
are exceptional.
Some people hoard their submissions and aren't willing to share. I'm willing to share.
Yes.
That's just, and I must give, my inspiration for that comes from Christopher Levingston.
Oh, yes. He's a sponsor of our show.
That's right. Accredited specialist immigration lawyer who's always happy to share submissions, and I think he really sets the bar for all of us
he does,
to follow in that, doesn't he?
Unbelievable.
So, look, what constitutes compelling reasons? Well, that's something we'll talk about at length in the webinar, but something to think about. Compelling often means circumstances that are beyond the control of the applicant or sponsor. It doesn't say that in the regs of the policy, but that's the thinking.
That is the thinking.
That's the
and now
thinking.
we're talking about natural disasters, war, other things.
Those are pretty extreme, don't you?
I'm just trying to go.
Well, they are. How about medical issues?
Medical issues are true.
You get hit by the beer truck.
Yeah, you get hit by a truck. Exactly. But I remember dealing with an example with Christopher Livingston, and it was incredible that there was a natural disaster.
Really?
Yeah.
Wow.
And it was in a medical treatment visa as well.
Yep.
It was unbelievable at the timing. It was when the Nepal earthquake occurred, and I thought, wow, it was one of the most monumental points of my career starting as a registered migration agent was seeing the timing of and witnessing what a compelling situation was.
Wow.
It was by far unbelievable.
So for compelling reasons, look for things that are beyond the control of the applicant and sponsor,
that is so
especially
important.
medical issues,
Exactly.
natural disasters,
Absolutely.
wars, famine,
Yes.
Holocaust, all that stuff.
Absolutely.
Anything that is they are utterly not in control of. What
Exactly.
doesn't work? Financial reasons.
Pregnancy.
Yeah, pregnancy, it's sort of a choice.
That's it. Be mindful of that.
Yep.
Especially the new registered migration agents that come out.
Yep.
You need to be aware of that.
However, traditionally, pregnancy has created an opportunity that in maybe 50% of the cases has led to a Schedule 3 waiver. Having a child is probably the best way to get a waiver because that puts the tribunal or the department in the position of having to split up the family if they send the applicant home for 1 to 2 years to wait offshore for an offshore partner visa.
Especially when the father or the mother is an Australian or permanent resident.
And may not be able to function well as a single parent.
Exactly, and you cannot disadvantage an Australian child.
Nope.
That's it. That's
However, it's no guarantee. I saw a case last year. It was a case that went all the way to the AAT, and the member basically concluded that they had a child to facilitate a visa.
Really?
Yeah, a Schedule 3 waiver
Really?
refused. Yep. I've only seen one of those though. In most cases, having a child
Probably,
works.
but possibly. That's really.
It was awful.
That is horrific. That's absolutely horrific.
So Schedule 3, check out all the parts that apply to your visa. Make sure they pass them all. If not, look for a waiver.
If not, book into Mark Northam's Schedule 3
we're always
webinar.
happy to help. We're always happy to help agents, other practitioners. That's one of the things we do. But the other thing is, look, if they're not going to make it through Schedule 3, it's my feeling that it's irresponsible and not correct to give them false hope that they will. They may just need to consider going offshore and bite the bullet and do the offshore application.
And it's not a bad thing, really. I mean, sometimes it's not that bad to do it. People will just like, yeah. I mean, it all depends, but sometimes it can be the best option.
It can be. So don't be afraid to tell them maybe not what they want to hear, but what they need to hear.
That's a good point. And on that note, I think we should finish that up. That was very good.
There we go. Thank you so much for joining us. As usual, I'm Mark Northam.
And I'm Monica Gruszka.
We'll see you next time.
See you next time. Thank you.
This episode of The Migration Show is sponsored by Christopher Levingston & Associates.
Yes, Christopher is a accredited immigration lawyer and has been for many years, and he has a wonderful offer for all you registered migration agents or anyone else in the field who needs a review on a failed AAT case.
That's it. If you have had an AAT case that did not get a positive result, Christopher has a standing offer for all RMAs to give you a free review of that case and give you advice as to whether there may be possibilities of taking it to the federal court or elsewhere. So if you have a unsuccessful AAT case or any other question, please send it to Christopher by email.
Yes, email is christopher@levingston.com.au, christopher@levingston.com.au.